Great. Thanks very much. So just to follow up a little bit, one of the topics we want to discuss was SB 1008 and how it changed how juveniles charged with Measure 11 crimes are prosecuted. And as you know, it means that they're not automatically waived into adult jurisdiction, and that the prosecutor would have to go to a judge to have a juvenile facing Measure 11 charges be tried as an adult. Um, my question, I guess, is do you have any, would you ever seek to prosecute a juvenile as an adult?
Yeah, yes is the answer.
Okay.
I supported SB 1008. I think it is good to treat juveniles as kids, and I think that legislation recognized the research and the brain science around development and how juveniles are different. They are cognitively developing all the way up until 25 years of age. I think that's really important for a court and a judge to take into consideration when they're considering whether or not somebody should be tried as an adult. But absolutely, I think there are circumstances. I just read, maybe it was in the Oregonian or another paper. I'm reading a lot of articles, but talking about a case in McMinnville that was particularly, it was a really, just from the, I don't know anything about the case other than what I've read in the paper, but the facts laid out in the newspaper were really, really terrifying and pretty egregious. I think that is the type of case, and it sounded to me like that DA did attempt to get that juvenile waived into adult court. From what I have read in the paper, that seems like a case that I would have also tried to convince a judge to waive into adult court. So I think there are times when we have to consider. I mean, even when we are taking into consideration the brain science and juveniles and their brain development, we also have to take into consideration public safety, long-term public safety. And if the sentence that can be achieved in juvenile court is not enough, in what my judgment would be to make sure the public is protected, I think that's the type of case that I would consider asking the judge to waive them into adult court so that we could get a sentence that is more commensurate with protecting the public, which would be, obviously one of my first and foremost jobs.
And this would be the case you're referring to. Is it the 17-year-old who allegedly slit the throat of his father's girlfriend and beat her to death with baseball bats? Okay.
Yeah, just a horrific case, and
Yes.
my heart goes out to the victims. It sounds like that was really obviously incredibly traumatic for them, and yeah, I think this is also, it pointed out another thing, which is, it's tough when laws change and when the legal landscape changes on victims, because, they go in with one set of conversations and expectations, and then to have that shift, I think that's something I'm thinking about this in the context of the Supreme Court decision yesterday in Ramos versus Louisiana. I think, we need to be very mindful about how that shifts victims' expectations, and doing everything we can to make sure that we're reaching out to them with, trauma-informed resources and making sure that they are, as okay as can be under the circumstances.
And one of the, sorry, I just lost the question that I had. With actually the case in McMinnville that you mentioned, it sounds like the judge concluded that this is what the law, the decision he had to make under the law to allow the teen to be kept in juvenile jurisdiction. Does that reflect a flaw in the law to you, or do you think that the law should allow or has a capacity to allow for juveniles to be, like in this case, to have been treated as an adult?
Yeah, I mean, obviously, I wasn't in the courtroom to hear the legal arguments, and so I read that the judge said that, and so if he felt like there was some part of the law that made it impossible for him to waive the juvenile into adult court, I think that's something that could be looked at, and that we should try to analyze, is there something, whenever you change laws and write new laws, I think you're always going to find unintended consequences or things that happen. And so if this case highlighted something that either was not intended by the legislature or prevented the judge from making that decision legally, I think it's something that we should absolutely learn from and go back and see if it still makes sense to have the law written as possible, or if it makes sense to change it in some way. I wouldn't be able to say from this case, obviously, because I don't know the legal arguments.
So would you support releasing the transcript of the proceedings in that instance? I mean, there is certainly a situation here where you have a new law, as you said, unintended consequences, and part of the ability of the public to weigh whether this is achieving what's intended is to see how it's being carried out. Is that something that you would support?
Well, I think it gets complicated in terms of the rules and protections that we have set up in place around juveniles in how they are treated and what is allowed to be released. And so I'm not entirely an expert in what is or is not allowed to be released in those situations, but I know that we have a lot of heightened protections for good reasons around juvenile hearings. So I think if the judge was caught on a legal argument, then I think that's something that should absolutely be explored, and that people should understand how that legal argument did or did not impact. I think it gets a little trickier potentially around any kind of juvenile cases and releasing certain facts. And I want to, be mindful that when you make a decision in one case, you're setting precedent for a lot of cases. And so, I know that we have good juvenile protections for a lot of reasons. So it's hard for me to say without knowing what the exact issue is. I think if it's not allowable by law to release the transcripts because it was a case involving a juvenile, I obviously would follow the law as the DA, but still try to make an attempt if the judge believes that there was some functioning of the law that wasn't working, to see how we could get that information to the legislature and to members of the public as well.
And Therese Bottomley has joined us. Therese, we were just talking about the case that Noelle wrote about yesterday in Yamhill County.
Or the Yamhill.
Right.
Okay.
And one of the questions I have is just in terms of being able to monitor how this law is working, and if it's achieving what legislators said it would, is to have transparency into the proceedings and to be able to have access to the transcript, for instance. I guess, and Therese can correct me on this if I'm wrong, that even with juvenile protection, wouldn't there still be a balancing of the public interest in terms of a court proceeding being something like that being made public, or the transcript being shared?
There's really, I think, a statutory fix needed. The proceeding is open in the sense that it's in open court, and that was a case the Oregonian fought back in the 80s. But the records, the juvenile court records, which includes the transcript of the hearing that was public, are not public.
Okay. Okay, and then finally, I guess, the question I have for you is, you've talked a lot about just ways that the prosecutor's office could be used more effectively, and that instead of kind of looking at these very punitive mandatory sentence type of solutions, looking at, how can you better ensure public safety without necessarily going to these prescriptive incarceration type solutions. I guess the question I have is, how would you assure the public that you will be a strong advocate of prosecution in serious crimes, that you aren't going to be that you're not coming at this from such a reform perspective that you would let them down or let victims down on the prosecutorial end?
Yeah, I think, for me, when I talk about reform, it really is how do we achieve better public safety? I've been as we talked about last time, looking at the research and the data, I see that our recidivism rates in both community corrections and for people who are released from prison is upwards of 50 and 60%, meaning that people are committing crimes again within 3 years at 50 to 60% of the rate. I mean, that's not a system that is achieving good public safety outcomes. So when I talk about reform, what I want to do is I want to see what can we do to maximize better outcomes. And there are systems across the world and country that are doing things better. And in Oregon, we've done some things that are meeting some of those goals. For example, there's the Family Sentencing Alternative Program, which is a program that we actually copied off of our neighbors to the north, Washington State, where parents of children who would otherwise be going to prison are given a chance to stay in the community, but with intense wraparound services that also include family, how to work as a family unit, things like reading to your children, preparing meals. Like, it really is a pretty wraparound program. Oregon has seen that since doing that, not only have we kept an estimated around 350 children out of our foster care system, which I think we all know is a system that's really laboring, but we've gotten a reduction in recidivism compared to the group that went to prison of about 17%. So when I talk about criminal justice reform, that's what I'm talking about, is how do we do things in a way where we get better public safety results? And I think it's learning from other programs. It's being open and honest that, I might support some things or think that we should try some new things. And then we're going to track the outcomes, and we're going to say, hey, actually, people in this program, they're worse. They're committing more crimes. Well, we need to scrap that then. But I think we need to be willing to try some things differently and just see, can we get better results? And when I went to Norway, got to tour their prison system, their recidivism rate is about 1/3 of what ours is, and their prison population is about 1/5 of what ours is. So they're incarcerating way less and getting way better public safety outcomes. And there's a whole lot of reasons that we can say about that probably don't entirely have to do with criminal justice policies, like their very strong healthcare, universal healthcare system, and other things like that. But I still think there are things that we can learn, and we should be open to investigating and then trying. And if we get better outcomes, that means less victims in our community. It doesn't mean not holding people accountable or not prosecuting people or looking the other way as if that's going to magically solve the issue. It's not. There's a lot of research around our drug courts that the way to get better results is with swift and certain sanctions and accountability. So for me, it's not, it's really, let's use the data. We have all this information, and let's make decisions based on that and not based on, fear mongering or anecdote. One of my biggest issues with mandatory sentencing is that it's mandatory. It doesn't look at the person in front of you, and it kind of sweeps up a broad group of people. I think that we should evaluate those cases on a case-by-case basis and use, let judges decide, let prosecutors make the best arguments, let defense attorneys and victims be heard by the court, and let's craft a sentence. We've done that for lower level crimes. Multnomah County has a very successful program called the Multnomah County Justice Reinvestment Program, affectionately known as McJERP. That's what they do. They sit down with a judge and they go through a detailed, almost like you both have probably seen these, the old PSIs, the time when the probation department would do an in-depth look at an individual offender before sentencing, a PSI, pre-sentence investigation. So do the deep dive on what brings this person here, what's driving the criminality. Do we have any resource in our community that might be better suited to getting the outcome that we want, which is less future crime? So for me, it's, that's what when I'm talking about reform, I think that we can actually get better public safety outcomes by doing things differently, and definitely, holding people accountable, prosecuting people when they're committing crimes. Those are important steps in holding, making sure that we're protecting the public. But then what do we do from there? How do we deal with those cases? And let's actually be open and honest and track the data if we're not making the community more safe, then let's change our tactics.
And I apologize because I said this would just be 10 minutes, but I did have one other question, and that was about, I'm not sure if you saw the story about the Multnomah County Mental Health Court unit where 4 people were dismissed, or I guess 4 people resigned as investigations were continuing about not meeting with clients or doing their own business on time that they were supposed to be meeting with people. What can you or would you do in that situation to make sure that the county is effectively managing some of these vital services that play right into your strategy for justice reform?
Yeah. Yeah, that was a really disappointing story to read about. You know, obviously I only know what I read in the papers, but it sounds like the employees were not following through on their duties and probably were being dishonest about what they were actually spending their time on. And, you know, at some level, we have to trust the professionals in our community are actually doing the things that they are saying that they're doing. And when we find out that they're not, then you know, then it sounds like they're moving on voluntarily, but probably were facing being terminated if they didn't. And that seems like the right thing. I'm a big believer in mental health courts. I'm a big believer in drug courts. I've been a deputy that sat in a drug court for over a year, working with people. I've seen how they can change people's lives around. People who initially, when they went into the drug court, I was kind of feeling like, I think this person's going to fail. They're going to be in prison and within a week. And then 2 years later, you know, they're back to completely being healthy, off of drugs, getting jobs, putting their lives back together. I've seen it work firsthand, and the research is also there. So it's not just my anecdotal experience, but the research is there supporting that those are effective interventions. So it's really disappointing to see when there are some folks who are in those roles and that we trust and are in a position of trust from the community, from the DA's office, from everybody else, and they let us down like that. My reaction, of course, would not be to scrap the mental health courts, but we obviously should look through that case and see if there were some warning signs or some things that we need to put into place to make sure that something like that doesn't happen again, where employees are not following through on their duties. I don't know what kind of oversight or check-ins were in place or what could be put into place. But whenever we have a failure of a system like that, I think we need to go back and look at, you know, what went wrong, how did we miss this for so long, and what can we do in the future to make sure that that doesn't happen again. So my hope is that's where the mental health court goes. I hope the program continues to exist. I believe in the program. But, you know, we have to make sure that our employees are following through and doing their jobs.
Great, thank you very much. Therese, did you have anything else?
I just had one question. I don't remember, we've had so many of these calls, I don't remember if it came up with the DA candidates, but, you know, we had a story 2 years ago, I think, on more than half the arrests in Portland being homeless people. And, you know, what happens is a cycle of then they fail to appear and they get, you know, warrant out for failure to appear, and then they get arrested, and then they get kicked again and get another failure to appear. So what role would the DA's office have in changing that dynamic?
Yeah, I think great question. I think that's a huge issue. You know, the way it's so inefficient. And then even, I talked to one of the deputy DAs in the office who deals with the arraignments, and I asked him about this very thing. And he told me that it's not until the 8th time you get picked up on your warrant that you'll actually be held by the court to have your case resolved. So apparently they go through that not just 1 or 2 times, but 8 times until somebody's held. And then the outcome from them getting their case resolved is frequently in community court, where it's, hey, can we hook you up with treatment or resources, or you're going to do 5 days in jail. And then we just start the cycle all over again. And it's just this revolving door of not doing anything differently. You know, I think the DA's office can play a big role in that, in trying to figure out, like, there are some things in pre-trial that we could be doing better in terms of supervision. There have been random control studies of just, is it effective to send people a text message reminder to show up to court? And you know, that might seem, you know, a little counterintuitive, especially for a homeless population, but I volunteered for a couple years on a board that works with, does outreach to homeless, to people living on the streets. And I'd say the majority of them had cell phones. And I think that's consistent. So with other people's experience. So sending people text message reminders could be a very low cost, low impact way to just remind them, hey, you have court today. Because, you know, they're attending with a lot of other circumstances in their lives that it's not unreasonable. If I have to be reminded to show up at the dentist, it's not unreasonable to think that somebody who doesn't know where their roof is going to be from a night to night basis is going to forget about court. So I think we could do some things low cost impact that are more effective, that we know would work. But then also just asking ourselves, like, what is the point? Because at the end of that case, at the end of 8 warrants going out, picked up and over and over and over again, to get a 2 or 3 or 5 day sanction in jail, and then we start the process all over again, that doesn't fix anything. I mean, it's a waste of a lot of resources, a lot of court time, prosecutor time, all of those things. So I think the DA in those types of cases should be asking, what are we trying to accomplish by doing this? What is the point of this? And I went to an expungement clinic and I sat across the table from a woman who was homeless for 9 years. And she talked about how she finally got off the streets, and it was because Central City Concern reached out to her and gave her access to the services and things that actually got her clean. I asked her about her 20-some convictions. I said, did that ever help? And she said, no, she didn't care about community service. She didn't care about the fines and fees. She didn't care about spending a night or a few hours in jail. None of that changed her behavior. It was then getting the Central City Concern. And then after the fact, once she actually was getting her life back together and put on track, that's when the fines and fees hit her. That's when the warrants and all those things that she needed to clean up all the wreckage from her life really impacted her negatively. So I think a district attorney can think about, you know, am I the right tool for this? Can we partner with the Central City Concern to do something different and out of the box, and not just repeating this because, well, a police report was filed, and if there's a police report filed, we have to prosecute charges, and if we have to prosecute charges, then we have to send out a warrant. If we have to send, and just doing this like the inevitable trains going down the tracks. I think we need to be honest with ourselves that that's not actually fixing or helping anything. And you know, there's no magic bullet, right? There are homeless courts, excuse me, around the country. There are about 12 states in my research that have them. Oregon is not one that does. I'd be very interested in looking to see if that's something that we could learn from. But I think, again, it's trying different things and just seeing, can we be more successful? Because what we're doing right now isn't helping anybody. It's not working. It's wasting a lot of resources. So I think we could do a lot better. And I think the DA has to be a big player at that table, and also be somebody who different community groups could work with and figure out, just trying new stuff.
Thank you. I have to jump off now. I've got somebody at my door, but thank you.
Okay, thanks. And Mike, one more. It's just, I'm sorry. This is a really interesting conversation, so I appreciate it. But drunk driving or just serious driving violations that are clear public safety hazards. Any quick ideas in terms of, like, you know, how you would change that dynamic? Because we do have repeat drunk drivers coming into court over and over again.
Yeah. You know, we have a DUI intensive supervision court DISP. You know, I'm a supporter of that program. I think that works, but you're right. You know, sometimes it gets to a point, and I've seen these cases, and I know the district attorney's office has battled over these cases where somebody gets their 9th or even more DUI conviction. And, you know, as hard as it is to say, because I do believe for most of the time it's get the treatment, get to the root cause, but there becomes a point where, you know, the treatment and the root cause is not going to get it done to protect people. And DUIs is one of the most dangerous crimes, I think, in our community. I've had, so a little criminal justice, I guess, dark humor. You know, I've had multiple people opine and say, you know, I'd rather have a murderer live next to me than a drunk driver, because the murderer is not likely to come over and kill me, but the drunk driver just might drive through my living room, you know. And I think that's accurate in a lot of ways. Drunk driving is incredibly dangerous, and it puts our community at risk. And you know, I think when somebody gets arrested and has that intervention and they can do diversion, that's a great thing. And, you know, even if it doesn't take the first time, you know, then you start to get insight into addiction, and relapse as part of that. And that's, you need to keep working on it. And that's really important. But boy, it does get to a point where obviously the treatment isn't working, and we do have to protect the community. And there are some situations where the only way to protect the community from someone who's unwilling to stop driving drunk is to make sure that they can't drive and that they aren't in the community.
Great, thank you. Thank you so much. And yes, we did go much longer than I promised we would, but I really appreciate your indulgence. This was really helpful. We have got, you know, 2 great candidates. So all this information really just helps us make our decision. So thank you.
Yeah, no problem. All right, good to talk to you both.
Okay, take care. Bye-bye.
Bye-bye.